And we've identified three primary categories of friction associated with ADR: the process itself, the neutrals, or mediators and arbitrators, and the results. So during our time together, we're going to explore how to address these pain points and how to develop a blueprint for when and how to engage in what we'll define as great ADR. So as we think about where to start, let's think about how to address a culture of win at all costs. Helping organizations maybe redefine what it means to win, which can and should include preserving relationships and other tangible and intangible costs associated with driving value for the businesses we represent. So, Paulette, let me start with you. What's your argument for non-litigation options to be the method of choice for resolving disputes when the company feels like they're certain to win and they'd likely prevail in court?
Good afternoon. Thanks so much. It's really great to be here this afternoon. So I smile as you pose that question because it's so curious to me as to why we're still saying this, why are we still talking about this when there's so much data that demonstrates that how beneficial ADR can be. And, the notion that we've got a great case, it's a slam dunk, there is no such thing. You can never predict, especially if you have a jury trial, you can never predict, even with all the jury consultants that you could possibly hire, you can never predict the outcome of a case. And so you have to first take that into consideration. You have to really carefully explain that nothing is 100% guaranteed. And even if you have a 60-40 situation or even a 80-20 situation, it could really backfire on you and create really repercussions that you don't want to have to deal with on the back end. It could create exorbitant costs. And as you mentioned early on, relationships with your customers and relationships even within your organization. So that if you have a legal department saying this, you think about the legal department does not really add to the bottom line of the organization. So you will have your business units saying, why did you take this risk when there's the slightest possibility that we cannot prevail? So ADR takes some of those stresses away from that sort of uncertainty that litigation brings. And, at the end of the day, even if you don't get the exact result that you want, it's worth the risk to take. And the earlier you engage in the ADR process, the better.
Thanks for that. Any of our other panel members want to address that question?
I absolutely agree with Paulette that there is no slam dunk. I think part of the problem is the existing cultural set points that many business organizations are involved. I think one, litigation is not well understood by General Counsel who come into those positions from transactional sides of the business. They really have no awareness of what the black box of litigation is. And so it's hard for them to understand without guidance what litigation threats there are. And in general, I think while there's been a massive change in the 40 years that I've been practicing from adversarial approaches to more facilitative approaches, it really isn't that hasn't progressed as much as I would have expected. Although I think it's quite ironic, the amount of litigation, actual cases litigated, tried, is precipitously fallen that same period. So litigation is being used as a settlement device. It's just the most expensive, destructive settlement method you can choose.
Really helpful. Saloni, just as we think about this issue, how should members of the audience think about the return on investment associated with dispute resolution? What factors, other than the cost of litigation and mediation, should be considered when people are selecting dispute resolution forums?
Sure, Bradley. I think there are a number of factors to consider based on the type of disputes you're dealing with, the type of business you're involved in, and the industry you're in. In my experience, one of the key factors was the strategic timing. So what are the business's kind of near-term and far-term goals? And, what toll will a long extended major litigation take on the business? Recently I was arbitrating a case with a large giant retailer, and we were just trying to decide an arbitration schedule. And even in that context, which is so much more efficient, the business said to me, we don't want our retail season impacted at all by this individual dispute. So in terms of really what are the strategic priorities of the business? Another thing that's really important to consider is reputational harm. So we live in a time where we have a lot of consumer advocacy, we have a lot of employee advocacy as well. And a long drawn out public dispute full of uncertainty can really impact the reputational harm of an entity. And oftentimes it can be irreparable. The other thing I've always considered is the risk associated with discovery itself. So sometimes discovery will reveal things that maybe was on no one's radar and we don't want revealed, and can really take a case in a different direction, set aside the huge costs of getting through discovery in a major litigation. The other thing I've personally experienced when I was in-house was the impact on the business, on the teams that are providing the data. So in this climate that we live in, where it's difficult to retain and get new talent, I think it's a big problem if a lot of their time is used with litigation support in terms of providing, witness testimony or data. I know in the context of wage and hour class actions, it's a huge impact on payroll teams, for example. The other thing I would mention is, given the nature of the dispute, the business might really prefer a more confidential or private resolution, something that they don't want, to be, again, in a public forum. And, I've also had the experience where oftentimes litigations can turn into strategic opportunities to acquire assets and do other things. So again, if the business's strategic initiative for a technology company is to acquire assets, through mediation, you can really turn that dispute around to make it, to add to your bottom line.
Thank you for that. Yeah, as you were recounting, the factors that go into that. One of the things you mentioned is some of the circumstances that make ADR more favorable than litigation and the discovery process that goes along with it. Paulette, I just wonder if you might offer some views on what type of cases or circumstances would you classify as unsuitable candidates for ADR?
Is obvious is a criminal case, and that can happen sort of in the corporate context where there are allegations of RICO violations and things of that sort. I don't necessarily think those cases are suitable for ADR, and I have to tell you, I confess, I just don't know how that would work. But there are some of the cases that we didn't traditionally think about as suitable for ADR, especially in the context of people saying, I've got to have my day in court sort of thing, like a lot of the discrimination cases and so forth. And people are now coming to realize that those cases are very appropriate for ADR, and even custody cases in the family law context, those cases are right now for ADR. So I think that there are really precious few types of matters that cannot successfully be directed to alternative dispute resolution.
Thanks for that.
Having facilitated some cases, this whole notion that the party needs to have his or her day in court, I think is easily accommodated even in a facilitation, much less an arbitration, where you sit there. I've had to listen and to people vent and try and redirect them into a positive way of thinking about how to resolve the dispute. even though they're very angry. The interesting thing is, I don't think the plaintiff side of the equation understands there's a lot of venting that goes on in the corporate or the organizational side of the equation. They're just as upset at being accused of doing wrongdoing. So whether it's facilitation, mediation, or arbitration, those are all vehicles for satisfying the need of the participants to have their story heard and meaningfully assessed, and cheaper, quicker than the adversarial litigation system.
Yeah. Bob,
Except that sometimes plaintiffs don't think about cheap or quick, especially if they're doing it on a contingency basis. So they really have to be talked down.
Well, yeah, I agree. If it doesn't seem to have a cost to you to do the litigation, that's a factor. But they do want to be heard.
Right. Oh, they definitely want to be heard.
And they don't mind having that happen sooner rather than later. And what they don't understand, which the facilitator can in particular explain, is, if you don't do this now, it could be 2-3 years later in the judicial system. So there is you can even explain to somebody who's on a contingency fee arrangement that there's a cost to them as well.
Right.
So Bob, just sticking with that and thinking about trying to the culture of dispute resolution that exists inside of a company or a legal department. How do organizations make dispute avoidance even and early resolution the prime mission of a legal department? And how do you get buy-in across the organization? I'm thinking in particular with the CEO, CFO, other C-suite colleagues.
I used to advise quite a few major corporations before I joined the judiciary, and it was also General Counsel. I actually have found CEOs a whole lot more receptive to the idea of avoiding litigation once you can sit down and talk to them. Those of us who are part of the legal guild are very much wedded to this notion of adversarial process. And even a number of arbitration organizations, when they create their structure, incorporate engraft all of the structure of litigation into the arbitration system in order to seem like they're not abandoning any of the safeguards that are thought to attend the litigation system. But the answer is, if you got a CEO who understands the process, and if you got a general counsel who understands why early intervention, early resolution is better than paying lawyers a lot of money till the oops happens. And I had been on the receiving end as a general counsel about it's okay, we're not 10 months, 11 months into it, we got to settle this.
Right.
So I'd rather always find that out early and resolve it than go through the process. CEOs understand that. CFOs can understand it.
Yeah.
But it's getting the general counsel to be the driver of that I think is most important to transforming the culture of adversarial versus alternative dispute resolution.
It's really, really, really helpful. Saloni or Paulette, any other insights on that question of how to get support and buy-in across the organization?
So one thing that was mentioned was about how the process is structured. And, that has actually been a barrier because sometimes people view that as you create these structures. It looks like a trial to me. It looks like regular litigation to me. Sometimes there's limited discovery, which can go into much larger discovery. So I think that, even though ADR is preferred, I think you have to really structure it in a way that doesn't look too much like litigation, because people will look and say, you want me to do these things? We have this discovery schedule. How is this any different than if I take it to trial? So I just I just view that as sort of a cautionary tale, to be mindful of, that you make sure that you are doing the most efficient and the most expeditious method of ADR. Well,
that raises a corresponding, in my view, cultural issue. If, for example, in the employment area, I mean, I was a crusader in the late 70s for importing arbitration into the workplace to resolve all manner of disputes, discrimination, contract, other. And so the question is, initially, is this mandatory? Is this a voluntary system? And so there are some delicate issues about, how do you persuade people, if it's voluntary, to participate? And if it's mandatory, what can you shear away from all of the armaments of litigation and still have what appears, at least to a judge, to be a fair process, fair enough to get the judicial imprimatur. When I was crusading to do these things, it was not at all clear to me or my clients that the Michigan judiciary, for example, would approve a waiver of litigation rights. Because I'm here to tell you, judges are part of the legal guild, and we don't like to real bargaining unit work. So those are some of the cultural issues out there that you have to weigh and understand.
Yeah.
I would agree with what my co-panelists have said, that what I found in-house is there's not a lot of awareness at the executive level of really what ADR is, what are the differences, what are the benefits in resolving that way. And however, once I was able to compel them of the benefits, I've always had the experience where executive leadership wants litigation wrapped up as fast as possible with the least amount of expense and the least amount of impact to the business. What I've noticed sometimes is having a harder time with my outside counsel partners who are experts, right? You're hiring probably the best lawyers in America. They are experts in their craft, and they want to try to, spend a little more time doing some of the traditional litigation things. And so a lot of times my job was to compel them that we want efficiency, we want immediacy here, and communicate the goals of the organization. So that's where I have found a little bit of challenge to move faster to ADR.
That's not just a challenge. I often found my outside counsel were my greatest adversary.
Yeah.
They're entirely reactive, culturally reactive. Plaintiff does this, we'll do this. Instead, I wanted to insist, I want a thorough, full body cavity investigation of this issue, and I want to know as soon as possible what your assessment is. That was so foreign a notion to my outside counsel, even though I was directing to do it. If you want to make cultural change, relying on outside counsel to do it is frankly against their pecuniary interests.
And I guess that's why I've never become wealthy.
There's that. Yeah.
I guess that's because I've never become wealthy, because my position is, let's get this resolved as quickly as we can. I've recommended ADR before we did one drop of discovery in litigation. I've recommended ADR as soon as the pleadings were filed. And so, but I guess that explains it. Why I never became rich as a lawyer.
Mm-hmm.
That's really helpful. Yeah. So in my experience, I always saw outside counsel struggling with kind of the risk assessment and whose risk it was to measure and take. And once they were educated about the fact that, we had a mature in-house corporate team that was these are your classmates and your colleagues. We just need the inputs so that we can make the risk-based decision based on our business. And that seemed to help them sort of recalibrate how they were thinking about the responsibility of carrying the risk assessment. That was ours to carry, not outside counsel's. Saloni, Paulette touched on this issue of arbitration looking like litigation. I just wonder, in your experience, what language can organizations include in commercial agreements to prevent arbitration from being litigation in disguise? Have you thought about that issue?
I sure have, Bradley. So I've had the opportunity as an arbitrator to review dozens of arbitration clauses. And I have to be frank, it's sometimes disappointing to me how little thought goes into the language of the arbitration clause, because prior to the dispute, the parties have so much ability to control that whole process. And so oftentimes it's very, very, the language is very kind of scant. And so some of the things that I think are really helpful in an arbitration clause are, number one, communicating a clear intent to resolve the dispute by arbitration. So there's no question as to what the parties wanted. Number two, really identifying the scope of the arbitration agreement. What disputes? If it's all matter of disputes, I would expressly say that. So again, avoiding the opportunity to litigate that issue as well. The third thing that's really important is to include the procedural rules that the parties select to manage the dispute. For example, the Alterity arbitration rules. If you want arbitration, you should expressly say, we would like to use the Alterity arbitration rules to manage the disputes that we have, between the parties. And on a similar note, you should also expressly state the substantive law that will govern the matter as well in the arbitration clause.
Saloni, let me just stop right there, because I think that's a really important point. Because a lot of arbitration agreements delegate to the X arbitration association the procedural rules. What makes Alterity procedural rules different from some of its competitors? So they're less litigation-like.
I have found the Alterity rules to be more efficient, to be honest with you, to be more efficient, and they resemble less of the traditional litigation procedure in terms of discovery and motions and other things.
Mm-hmm. Okay.
Anybody else on that point regarding the Alterity arbitration rules?
So it's very important, because if what you're doing is importing all the adversarial procedures into an arbitration, it may be marginally more efficient, but it's not as efficient as it could be.
I absolutely agree with you, Bob. And I think another thing that parties can do in the clause itself, so beyond the procedural rules, is specify what type of discovery are they going to have depositions? Are they going to allow, interrogatories and document requests? Or is there a provision for motions? So all of those things can be specified within the arbitration agreement, to control the dispute at the onset. And as I said, I rarely see that much thought put into the process. The only other thing that I would say as a thought that I have found effective is parties may consider a tiered dispute resolution clause where they, based on the type of dispute, they consider mediation first, or they consider mediation simultaneously to arbitration to ensure that, one, the dispute doesn't get to litigation, and two, to really make it as efficient as possible in terms of resolving the matter.
There's one thing, depending on how broad the arbitration provision is, if it encompasses a wide range of disputes, it may well be to have a tiered approach, but the arbitrator is charged with the responsibility of finding the most efficient level of complexity given the nature of the dispute. That's another way of not having a too prescriptive set of procedures, but one that's flexible but allows the arbitrator to drive the efficiency.
I agree.
That's great. Great discussion on that point. Bob, just to stick with you for a minute, how should general counsels think about creating a system that evaluates lawyers, outside counsel, paralegals that are involved, not merely on lawsuits won or lost, but on disputes avoided, costs saved, and maybe even crafting creative solutions that are preserving and enhancing relationships.
A whole lot of metrics out there, ways of measuring efficacy of those things that have emerged since I was actively out there practicing. I know there are a number of companies that have internal groups within either the General Counsel's office or adjacent that are specialists in early dispute resolution, and they use all these metrics. They have ombudsman. They go out into the organizational's transactional areas where the dispute arose to gather data and make those assessments. Those are all out there now. They weren't available to me when I was actively practicing, but they are there now.
Yeah.
And for a price, you can buy them.
I think that most people should be in tune to cases that may be ripe for alternative dispute resolution. I think the issue becomes one of managing the resources that you have within your organization, and also once again measuring the benefit of isolating certain individuals within your organization that you will take the time, effort, and money to train them to do this particular function, and whether organizations are ready to see that as a proper investment. Are they willing to look at it further down the road as opposed to looking at the benefit of here and now? And I think that is sort of what has brought us to this particular place and the journey that it has taken. To me, the obvious answer is yes, that this would be a very wise investment, and it would also free up those who are at a higher level of responsibility, compensation, etc. And it ultimately, at the end of the day, it would still add to the bottom line. It would be a cost benefit to the organization to have individuals who are specifically trained to be able to recognize claims that are ripe, and when they are ripe or when they may be ripe, especially those who have been in an organization who have focused on gathering discovery information for the organization, and understand the amount of time that it takes, both in actual time and in money, all sorts of variety of resources to go through protracted litigation. So I think the benefit is tremendous to have those individuals specifically trained to do that function.
I have been the general counsel in an organization, a fairly substantial one, that had been under two simultaneous class action orders. And for a decade, the general counsel staff and HR ran all HR functions. It resulted in the total atrophy of the management in understanding or dealing with HR issues. So I had a twin problem when I became general counsel. One, to claw back the power that my staff had been exercising over all management decisions, essentially. I mean, this was a very significant turnabout. And then re-educating the senior management about their responsibility to take on those functions. And that's a very difficult, it doesn't happen overnight. Yeah. Some senior managers just don't have gene receptors for that kind of responsibility. But you've got to understand what your organization is. And the larger it is, the more complicated it is to understand how segments of that entity work and how effective they are.
It dovetails back into an earlier question that we talked about, and that is getting C-suite support for the strategy. To your point, if the team's not viewed as competent in this space and performing at a high level, it makes it harder for the general counsel to get that cross C-suite support for the strategy.
And it's never anticipated that the staff people will be the final decision makers in this. So it's sort of like, in a law firm context, you tell the paralegal there are limitations as to what you do. You cannot give legal advice, for example. And so, there's always an attorney or another person who has to be ultimately responsible. But I think that it sort of still creates a good shortcut.
Here's the problem. Using your analogy of the paralegal not giving legal advice or a young associate, if you're on top of that, you have a obtuse partner who is uninterested in floating and exploring the issue that needs to be explored, you have a problem. That's the cultural problem at the senior management level, and how you address that. Even if you got a CEO who's committed, he has to be committed to reforming his senior management team, or she does.
I would just add that in my experience, I think that in the employment context, in the retail consumer context, I think if internal employees are trained to identify risk, have the ability to reduce risk, I think it goes a very long way. In my experience, I've handled several dozen consumer class action matters where at one point plaintiff's counsel said, the class actions stem from being treated so poorly. The class actions really stem from your customer service people hanging up on them. They don't stem from the fact that the data was less than what they paid for. So I've had that experience, and I've also had the experience in major employment litigation, where the employee might have had wrongdoing or misconduct, but based on the way they were treated, were they asked to leave and their pay was cut off immediately, or were they treated like a human and given a 2-week buffer to pay their rent? I think all of those factors really come into disputes, and I think that's one of the benefits of ADR, where you can get to the human side of disputes
quicker,
resolve it more efficiently.
Yeah.
All organization is because the line management or supervision is not aligned with the company, and they tell the people, I don't care.
Yeah. So the great discussion. I'm going to keep us moving along. There is related to this. I wonder, I'd like perspectives from each of you. Would you ever, and under what circumstances, would you encourage your organization to try executive level negotiation first, without lawyers, or maybe with an arbitrator or mediator present, to directly resolve the dispute? And why or why not?
The executive is. It really all comes down to competence. There's some executives who are really quite acute in terms of negotiating. There are others who are obtuse and awkward. So you have to know who the persons are that you want to empower to go off and negotiate. There's some people that I worked with who are quite able.
Yeah.
I can think of a couple people I would never let them near.
Yeah, exactly. Exactly.
I can think of certain commercial contexts, maybe in a sensitive or very competitive industry, where there may be value in having leadership meet early on with a facilitator or a neutral to kind of, generally discuss really what's at the heart of the dispute. Yeah. Like my colleague said, I would caution that sometimes, you have leadership saying a lot more than they need to. I would probably have an NDA in place, and I would probably counsel them as to what's proprietary and what should be discussed and what should be avoided. But I think that there are really competitive dispute situations where there could be value in having,
Let me just mention one other thing. The tendency is always want to escalate to the highest level in the organization. There's a lot of talent below the executive level. They're the ones that are actually dealing with the transaction. They actually know what the transaction is. It might be appropriate, instead of having the vice president go into the negotiation, might be the supervisor level, somebody who really knows and is canning. So again, these are the kinds of evaluations the General Counsel's office
Yep.
should be making to help if you want to have a customer negotiation. Those are the kinds of things the General Counsel can help facilitate, it seems to me.
Yeah, I think your comments on this point I think are spot on, and these are actually the kind of things that do lead to ultimately creating kind of that blueprint for greater dispute avoidance, minimization, and resolution. So really good. So I'm gonna shift just a little bit and talk a little bit about the logistics of dispute resolution and focus maybe a little bit on how we select mediators and arbitrator. Saloni, I wonder when you're selecting ADR professionals, how should our audience think about the due diligence to ensure prospective mediators and arbitrators have invested in staying technically competent, have the right history of being prepared? What do you think about in terms of the blueprint requirements for ensuring preparedness?
Sure, Bradley. When I think about my own kind of goals when I was in-house, when I was in private practice, in choosing a neutral, and to me, two things were really paramount. One was expertise in the subject matter. And so I would look at, the currency and recency of their authorship, of their contribution to professional panels,
Right.
of their membership in like exclusive organizations like the College of Labor and Employment, like, Paulette is in. I also, when I was in-house, relied a lot on my outside counsel to share with me the perspective of who was really committed to resolution, because you spend 8 hours or however long you spend in a mediation or several days in an arbitration, and you really want someone that's committed to bringing the parties together and having a result. You're not really there for a fact-finding mission. And so, what's interesting is I relied heavily on my outside counsel because they were doing this all the time. In my experience, over 15 years, there was one instance where I had a diverse neutral, recommended to me, despite my asking constantly, like, especially in the employment context, where aren't there any women neutrals that have experience and that can partner with us to resolve this? And so, I would say that while that type of, referral is one thing, it's limited because it's maybe who they've known or who they've selected or who's in their network. I think what would be great is if there were like a referral where reviews of other, counsel could be understood in terms of these different objective criteria. Were they efficient? Were they committed? Were they knowledgeable? To have a bigger bank of neutrals to choose from.
This is why Alterity is so significant and important to me. As General Counsel, I had another function, the litigation function that reported to me. We had 6,000 cases that came into that function every year. And we had difficulty recruiting or referring out some of those cases to minority and women attorneys. And the leadership of that organization, I asked, well, why aren't I getting any of these people? I said, we don't know anybody. And so who you go to church with, who you socialize with, those are your network. Have you ever been interviewed before you've been hired as a mediator or
Yes.
an arbitrator? Have you?
Yes.
Okay.
Yes.
Okay. I've never been. Saloni, have you?
That's because it's you.
I'm eliminated before anybody wants to talk to me. Is that what you're saying?
Well, thanks for that. Saloni, were you going to comment on that? I didn't mean to cut you off.
No, Bradley, I was just going to say I have not been interviewed either in any neutral roles I've served in, but I happen to believe, to your question, I think emotional intelligence is important. And I can't, count the number of times when I was, in a defense position where I would say to my clients, take the emotion out of this. It's, a commercial dispute, what fuels the dispute are these kind of emotional ideas that folks have. And I think that once, if it's possible, it's not possible for everybody to separate the two, but once you can get to resolution faster.
That's great. Really helpful.
I just understand that I don't believe that emotion should be involved, but I do believe the different perspectives that people have should come to bear. Maybe not so much in a contract dispute.
Yeah.
Pretty cut and dry. Yeah.
Fair enough.
No. I've had some contract disputes that are pretty furious.
Yeah. So we are 6 minutes before the top of the hour, and I just want to shift now to take a couple of questions that have come in. I've got one here that pertains to the first question that we asked, and that was, what's the argument for non-litigation options to be the method of choice in resolving disputes? And this question is, pertaining to the first question, the other side of the coin on this point is that we as arbitrators are obligated to, at a minimum, provide a fundamental fairness and due process. There's a balance to strike between a streamlined process and due process. What is the balance?
Depends on what the case is. There's no reason to have an elaborate discovery process for a very straightforward case where all the facts are actually known.
Mm-hmm.
And an arbitrator that is hamstrung by procedures that presume that every case is a antitrust case is going to be therefore adding expense where none is required. Due process is specific to the circumstance.
Good. Any of our other panelists want to weigh in?
I just thought that the question that was posed, I thought that the answer was really embedded in the question that he asked, that you have to evaluate each case to make that determination. That it's not a cookie cutter situation,
Yeah.
I would just add that kind of fundamental to due process is also the opportunity to be heard. And, I think I agree with the judge. Discovery is a big piece of this, of most disputes. But I also think that, the ability to control the arbitration or the mediation process, the type of hearing you have, the type of submissions you make are all, are kind of different elements of ensuring due process, that each party is heard and that a dispute is decided once those checks and balances are, in place.
Yeah, really, really good.
It helps if the arbitrator has a good BS detector.
A what? As a what?
A BS detector. So you just don't take the crap.
Oh, for sure.
You just don't go for the okie doke in these things.
Hey guys, let me sneak one more in if we can. This question is as follows. The bulk of my mediation work is in the labor employment context. Most often, there are so many elements fueling the conflict rather than just the issue presented in mediation. How much time should you spend, or how deep do you go with getting to the several root causes of conflict to get to the more complete and robust settlement? And how do you handle parties reluctant to share those additional details? My concern is the issue will continue to persist beyond paper settlement if the root issues are not dealt with. It's a really good question.
Are we arbitrating or mediating? If we're mediating, you can perhaps get into some of that. You can talk to the parties and say, this is going to be a recurrent problem for you. What do you do? In fact, that was in my early career, that was a lot of what I did with my clients, is say, we're going to do the litigation, but you need to fix this problem.
Right.
If you're arbitrating, I think you have more limited opportunities. You're really a neutral trying to decide the fact question before you, the legal question. So it's a little less opportunity to facilitate, but you can. What you put in your opinions and your orders can help point the way to the parties to think more deeply about what the issues are than this specific case.
Mm-hmm.
and it sort of goes to Saloni's point about, the emotion part. So, where, at what point do you check how you may feel emotionally or personally about it? And I think that there's less opportunity to do it when you're an arbitrator.
Right.
Yeah. Good. Saloni?
I thought it was kind of a complex question. It seemed to be in the context of employment matters and mediation. And it made me, frankly, think about lots of instances where, there are employees that have a myriad of challenges and issues with the employer. And I thought to myself, well, it's going to be a tough job for their counsel to hone them in. And I kind of identify what are the material and key issues that can be decided with a legal remedy, right? Because there are lots of things that cannot be, things that you're unhappy about, things that are not actionable. And I think that, again, in ADR, parties are represented by counsel often, not all the time. And I think it's that counsel's job. And oftentimes the mediator has an opportunity to persuade, that individual in terms of the breadth of their claims.
Yeah.
But sometimes you can't come to terms if you don't include some of those other remedial types of actions.
It's true.
It's good. We are 1 minute before the top of the hour, and I can't thank this panel enough for just an incredible discussion, really meaningful. And after this, we will produce the thoughts that were expressed here to give us all, as part of this dispute resolution community, something to think about in terms of the blueprint for great ADR. As I mentioned at the top, this is the first of a series that we will hold to bring our community of dispute resolution professionals together, so that together we can work on becoming great. Encourage you to give us feedback so that we can get better in the future at doing this, and we are covering the topics you want us to cover. So again, thank you all so much for taking time out of your busy days to join us, and thanks to the panel. Cheers, everyone. Have a great day.